Under CCPA, which of the following scenarios obligates a business to comply with a consumer's request to delete their personal information? A. The consumer has provided personal information through a third-party service that shares data with the business. B. The personal information was collected more than 12 months prior to the request. C. The business collected the information directly from the consumer, and it is not necessary for the business to maintain the consumer's personal information for reasons outlined under CCPA exceptions. D. The consumer has opted out of the sale of their personal information, but provided it as part of a loyalty program. Correct answer. C. Explanation. CCPA grants consumers the right to request the deletion of their personal information held by a business, provided that information was collected directly from them and is not necessary for the business to retain for certain purposes. These purposes include completing transactions, detecting security incidents, complying with legal obligations, and other uses outlined in the CCPA. This right is subject to several exceptions where businesses may deny the request to delete if the information is needed for specific lawful purposes. How does CCPA define a sale of personal information? And what are the implications for businesses regarding consumer opt-out requests? A sale under CCPA strictly refers to monetary transactions where personal information is exchanged for cash. B. The definition of a sale includes disclosing, disseminating, making available, transferring, or otherwise communicating a consumer's personal information by the business to another business or a third party for monetary or other valuable consideration. C. Businesses are required to obtain affirmative consent from consumers before any sale of personal information, regardless of the consumer's age. D. Once a consumer opts out of the sale of their personal information, a business is prohibited from requesting reauthorization to sell the consumer's information for a period of 12 months. Correct answer. B. Explanation. CCPA adopts a broad definition of sale, which encompasses transferring or making available a consumer's personal information to another business or third party in exchange for monetary or other valuable consideration. This definition extends beyond direct financial transactions to include other forms of value exchanges. When a consumer opts out of the sale of their personal information, the business must respect this decision and is prohibited from selling the individual's information unless the consumer later provides express authorization. What specific obligations does CCPA impose on businesses regarding the collection of consumers' personal information? A. Businesses must disclose the categories of personal information to be collected and the purposes for which it is used at or before the point of collection. B. Businesses are required to collect personal information from consumers only after receiving express written consent for each category of information collected. CCPA mandates that businesses implement a universal opt-in for the collection of all types of personal information to streamline consumer requests. D. Upon collecting personal information, businesses are obliged to automatically enroll consumers in their most privacy-friendly options, requiring consumers to opt into less restrictive settings manually. Correct answer. A. Explanation. CCPA requires businesses to inform consumers at or before the point of collecting personal information about the categories of personal information they intend to collect and the purposes for which the information will be used. This obligation is designed to provide transparency and ensure that consumers are aware of how their information is being handled. Unlike GDPR, CCPA does not require express consent for the collection of personal information but mandates clear disclosure about collection practices. Regarding the right to non-discrimination under CCPA, which of the following practices would be considered a violation? A. Offering a financial incentive including payments to consumers as compensation for the collection, sale, or deletion of their personal information. B. Providing a different level or quality of goods or services to the consumer because they exercised their rights under the CCPA. C. Implementing a loyalty program that rewards consumers for allowing the collection and sale of their personal information. D. Requiring verification of the consumer's identity before processing a request to know or a request to delete their personal information. Correct answer. B. Explanation. CCPA's right to non-discrimination prohibits businesses from discriminating against consumers for exercising their privacy rights under the Act. This includes denying goods or services, charging different prices, providing a different level or quality of goods or services, or suggesting that the consumer will receive a different price or rate for goods or services or a different level or quality of goods or services. While businesses can offer financial incentives for the collection or sale of personal information, they cannot penalize consumers for exercising their rights, such as opting out of the sale of their personal information. Under CCPA, when is a business required to conduct a privacy impact assessment? And what does it entail? A CCPA requires a privacy impact assessment for any new technology or business practice that may impact consumer privacy, focusing on evaluating compliance with the Act's principles. B. A privacy impact assessment is mandated annually as a general compliance check to ensure ongoing adherence to CCPA, regardless of changes in business practices or technologies. C. Privacy impact assessments are specifically required before launching marketing campaigns that use personal information obtained from third parties. D. CCPA does not explicitly require privacy impact assessments. However, it is considered a best practice for businesses to voluntarily conduct such assessments to ensure CCPA compliance. Correct answer D. Explanation. Unlike the GDPR, which explicitly requires data protection impact assessments, DPIAs, for processing that is likely to result in a high risk to the rights and freedoms of individuals, CCPA does not specifically mandate privacy impact assessments. However, conducting such assessments is considered a best practice under CCPA and broader privacy governance frameworks. These assessments help businesses identify and mitigate risks related to the processing of personal information, ensuring that consumer rights are protected in accordance with CCPA requirements.